Can your estate plan be private? I'm Michael Redden, and today that's what we're going to talk about. I got this question recently from a potential client, and it's one that's very important to people. So if you have any questions or concerns about it, please put them in the comments below, and I'll try to address those as well. But generally speaking, as far as the estate plans being private, we need to do one thing first, and that is distinguish between what is private and what is secret. We usually don't want to keep our estate plans and things secret. We want our family at least to know that we have one. We want particular family members sometimes to know that they might be getting things, or at least know what our wishes are. This becomes very important if we're going to disinherit someone or do something that's unexpected, because we don't want our family to think that someone came and influenced us, or maybe that they twisted our arm. What we want our family to do is to say that, yeah, this is kind of what we expect. This is their wishes, and that's what's there. We don't want to give them any reason to really question whether or not what's in the plan is accurate or things like that, because that will potentially cause a problem. But, sometimes we don't want the whole world to know how much money is going, or how much we had, or maybe specific members not to know. There are folks out there that will unfortunately see that probate happens, or see that someone got a large inheritance, and all of a sudden they'll be calling and saying, hey, come invest in my new company, come do this, come do that, and they'll kind of try to take advantage of that, and sometimes they'll prey upon those heirs a little bit. Additionally, if we're still living and we need some help, and the court has to name a guardian over us and things, a lot of our affairs, whether they're medical, personal, or financial, become public because they become a part of a court record. And so we'll kind of talk about estate plans themselves and what they can do about privacy. A will itself, once you're gone, is never going to be private. It's private while you're alive, only in so much that you haven't really shown it to people. But people need to know where it is if something happens to you, because a lost will is treated like one that you just tore up and revoked. So people need to know where that will is. They need to know where to find it if something happens to you. But then that will gets probated, and probate is a public process. The judge is going to look at the will and say, yep, it's a properly formatted will. They're going to admit it to court. It's going to be a part of the court records. People are going to know things about that. And sometimes people even record these wills with the property records as a part of the probate orders and things to show that property should have transferred to the right person. So if you want to be private about things, a will's not the way to go. A will's going to be fairly public, and it does nothing for that aspect of if you're going to have to get a guardian or a conservator to help take care of you. It does nothing to prevent that stuff from being a part of a court record and a part of things for the public. Now, as far as the trust goes, trusts, even after you're gone, they're not really something that most people have just like the public right to know about. There's not going to be a court record. There's not going to be the secret thing where even the beneficiaries doesn't know what's going on, though, usually. The beneficiaries are going to have a right to see the trust. How are they going to know if the trustee's doing what they're supposed to do? How are they going to know if the trustee's making errors and things and not acting in their best interest if they don't know about the trust? So they're going to know those kinds of things. And if they share the trust or share the list of the trust assets with people, then yeah, it's going to get out and people are going to know about it. But no one's going to have the right to just know. And no one can just request to know. And the other part about this too is that it's not going to be a part of that public record. If you, for some reason, have to be declared incompetent and things like that, just a different trustee will step into that trust. That trust itself doesn't become part of that court record that anyone can come down and see. And because of that, you can keep that kind of semblance of privacy, at least for living probate. But you have to be careful too, because if you don't fund that trust and put all the things that you want to keep private into it, then it's not going to do you much good. If that's not going to go in there until you die because you wanted to have that kind of control in life, even though you had a trust, then it's not going to be private. It's going to become a part of that guardianship and conservatorship file. So it's important for the privacy concerns, if you want something like that, to have a trust and to have it funded with things so the trustee has control over them. There's also a lot less likelihood that if there's a trust there that people are going to come out of the woodwork and want to take advantage of your heirs, because whether they're creditors or anything like that, they're not going to have a right to know what's inside the trust. They may have a right to ask if things about the trust to find out if they could potentially get a piece of it, but they don't have a right just to see it. Even if they sue, it's unlikely they're going to get to see the whole thing. It's possible, though. But those people coming out of the woodwork or people divorcing and things like that probably aren't going to get a whole lot of look inside of it beyond the fact to find out that they don't get to have any of it. So those same people say, hey, let's go invest in things and things like that. One, they're not going to know how much your heirs are even going to have. Two, the trustee is the person who hands that stuff out, not the heir. The heir could request it, and the trustee thinks it's a good idea, it could happen. But there's an extra person in there to kind of keep things private and protect things. But as far as privacy is concerned, about the best we can do is a trust, because people don't have just the right to get into that and look. And it's probably not going to become a part of a court record. Whereas a will, it has to be probated. It's going to be in the public record. It's going to be out there. And it does nothing for that living probate situation where all of your assets become part of a court file and get managed that way. So that's important to know, the difference between private and secret. And you really shouldn't keep your estate plan secret, at least from your loved ones. But you can definitely keep things private and put a lot more privacy on that. Nothing's bulletproof. Nothing's perfect. There are ways people can get to look at those things. But for the most part, if you use a trust, things will be kept very private.